2019.
Appeal has been dismissed. You go through, there is a recent judgment of 2022 Supreme Court. The requirement of section 63 has to be proved convincingly by adducing substantive evidence. Even a mechanical compliance has held to be not enough. And here I find that there are sufficient contradictions.
For judgment, J 1 of 2019.
Appeal has been dismissed. Yes, please.
May please, your lordship. Lordship, madam, time being for the passport.
Yes, Mr. Mahmood.
Well, we have filed affidavit in the opposition. And think this is the case, my lord. One case is this is WPC number 1 2022 that has been filed seeking CBI investigation into my case, because the investigating officer is the accused in my case, as that is the OC Borpata PS. He is one of the party to the killing of my brother Hasibul Islam when he was in Borpata district jail. It is their case that he committed suicide. Our case is that, and their case is that committed suicide inside the latrine. That is their case. But the Borpata district jail, where the under trial prisoners are kept, that is hardly 3 foot high. 3 feet high.
So you argue your case.
Our prayer,
For admission.
yes.
You
So, my lord, that is not possible. And there is a conspiracy that some amount of money in 60,000 was taken by one constable who was in the gate. That is this person, Ranjit Bayan. So he took some amount from him, and I think it is evident in the CCTV camera of the gate of the jail. And also some amount was taken by the private respondent. Oh, it is that is private respondent is, my lord, that is some Fiddus Ali, respondent number 8. It is the allegation was that Fiddus Ali's daughter has been kidnapped by Hasibul Islam, who is my younger brother. So in that case, police arrested him, and in conspiracy with the private respondents, they have killed my younger brother inside the jail, and has given it a color that he committed suicide, which is not possible, because in the latrine where this incident allegedly happened, that if a person sits on the commode or that place, then his head is totally visible from outside. So he cannot commit. There is no any other, that is totally open. We were not allowed even to visit the place where he allegedly committed suicide. And over and above, my lord, very hurriedly, this person who was the main person in my case, Firdous Ali, whose daughter was allegedly kidnapped.
So are you asking this court to find out whether he committed suicide or not?
No, our prayer is this case should be transferred to CBI.
You make
Or-
out, you argue your case.
That is my submitting.
Hmm.
Our submission is this. It is not at all believable.
Show us from the materials on
Yes,
record.
I am coming one after another. That for a moment, Lordship, kindly see page 21
Page 21 of which paper book?
of
Item?
WPC number 122.
Give
Give it.
122. Yes.
Page 21, kindly see. Now, my lord, here, Firdous Ali is the complainant.
Page?
Page 21, Annexer 1. He filed the case against number 1 accused Hasibul Islam. And then Jamaluddin, Saiful Islam is the present petitioner, my lord. And Kodbhanu is the mother of deceased Hasibul Islam. So residents of so-and-so, to our prayer was, prayer to arrest accused and to investigate the matter, page 22, and keep the accused in jail hazard and justice should be provided. Now, the humble prayer of the complainant is that the accused number 1 has kidnapped his minor daughter, namely Shabnur Khatun, as 15 years 6 months, and took her to an unknown place on 25/9/21 at 11 a.m. Saturday, including her in various ways. After that, accused number 2, 3, and 4, who are guardians of the accused number 1, has apprised him to take the kidnapped girl to an unknown place. Advised him, sorry, my lord. During the time of kidnapping the girl, the accused has also looted gold and silver ornaments and also rupees 80,000.
What is going on here? Two conferences cannot go on in the court.
I'm sorry.
Yes. Yes.
Well, 80,000 from the table of the complainant. It is doubted that the accused number 1 could have get physical relation with the girl without her consent at that unknown place. For this bad work of the accused, the complainant had faced irreparable, irreplaceable damage of prestige. There are witnesses of the incident. The reason of the delay lodging the affair is for that the complainant was busy in charging the guard. So, my lord, this is the case filed against Hasibul Islam and others, including the present petitioner, that we have advised him that we are part of the conspiracy. So, this was their case, this Firdous Ali. Now, Lordship would kindly come to.
You are appearing for one of the accused person in this
Yes.
complaint
But
case.
in that case, in this case, my lord, already, as my information goes, final report has been submitted because principal accused has been killed. In our ward, she has been killed. In their ward, he committed suicide. So rest of the accused persons are brothers and mothers of the mother of petitioner,
Who has been killed? What is his name?
Hasibul Islam. Number 1 accused. Page 21, Hasibul Islam. So this Jamaluddin is his brother. This Saiful Islam present.
So, what is the prayer in this writ petition?
Yes, fine. That Lordship may kindly see page 70. An operative portion may be seen page 18. To show cause as to why the investigation of Borpeta PS case number 2222/2021 under section so and so of IPC shall not be directed to hand over to the Central Bureau of Investigation to make the investigation free, fair, uninfluenced, and acceptable, considering the facts and circumstances of the case, and to bring all the criminals involved in the murder, alleged suicide case of Hasibul Islam, the younger brother of the petitioner, into a logical end, and or to show cause as to why.
So, Borpeta PS case number 2222 of 2021 was lodged on the basis of which FIR?
After killing,
FIR.
that affair you have annexed, yes, sir. That affair may be seen. That may be seen, my lord. Page 27. Complainant Saiful Islam, son of so-and-so, village so-and-so, accused Fiddus Ali, Afazuddin, Jinnat Ali, these are the name of private respondents. Number 2 accused is from Baniarapara. I am reading the contents. The details of the complaint is that on 27/9/21, accused number 1 lodged an FIR before the police station Borpeta against my younger brother, namely Hasibul Islam, filed Borpeta case number so-and-so. On 29/9/21, on the basis of advice given by accused number 3, he has surrendered to the Borpeta police station. After that, Borpeta police forwarded him to the honorable court, and the honorable court sent him to jail. On 12/10/21, about 2:30 p.m., my younger sisters, namely Abida Khatun and Hasina Khatun, went to Borpeta jail to meet Hasibul Islam. After their meeting, they saw that one accused, namely Shaukat Ali, who was in jail, took my brother from there, and by giving his hand over his neck, that means he was touched in this manner. This accused Shaukat Ali was taking him, not the police. That means private persons were also given indulgence, then they can do anything with my younger brother. It is also mentioned that an officer, namely Ranjit Bayon, gave me various types of temptation and said that he will give all kind of opportunity and protection in the jail to my brother, and also took rupees 60,000 from me in presence of Sadullah Ali. After meeting with my brother, my 2 sisters came back home, and after about 3 hours, we heard that our brother had committed suicide. It is mentioned that accused number 3 took bribe of rupees 10,000 from me. On 9/10/2021, at about 7:30 a.m., accused number 2 demanded rupees 10 lakhs and threatened me that if I do not give him money, then he will kill my brother in jail. And other accused also demanded money from me, otherwise threatened to kill my brother. After communications with jail authorities through the inmates who are already in jail, I doubt deeply that accused are with a complete secret conspiracy have killed my brother, so it has become necessary to arrest the accused in the matter for questioning. As such, I pray to take appropriate action against the accused. So in this case, my lord, this is the case number 2221 of Borpeta PS case under section 120B, 420, 406, 384, 506 IBC. So police has registered this case in a wrong section. Our prayer, he has been killed. 302 is not added. This officer inside Borpeta police station. Then, my lord, when no proper action was taken, then, my lord, I approached the learned State Police Accountability Commission, that is page 34. Annexure 3. Regarding a petition filed by the aggrieved petitioner, namely Saiful Islam, son of late Hussain Ali, situated at village Daukamari, post office Jonia PS and district Borpeta, Assam, against named accused person so-and-so, my lord. With the above subject, I would like to inform you the following few lines as sought for favor of your kind perusal and to pass a sympathetic orders which your honor deem fit and proper. That, sir, as regards the above noted red-handed accused persons are random involvement in this alleged offense, and they were playing a drama to commit murder of my younger brother Hasibul Islam. It is a fact that accused Afazuddin and Jinnat Ali are the main master of this instant effects. They were leading the old playing a dirty game to commit murder of my younger brother Hasibul Islam by the other accused persons. other equipment jointly. And number two, that sir, as regards it is reliable fact that a case was lost on 27/9/21 by the accused Firdous Ali being perpetrator case number 2109/21 against my younger brother Hasibul Islam, which is fabulous, imaginary, baseless, and concocted one. That sir, as regards the pre-prosecution history of this instant case is that on 29/9/21, my younger brother was forwarded by police of Borpeta PS. Since then, my said younger brother was languishing in the judicial custody on 12/10/21 at about 2:30 p.m. My two younger sisters, Abida Khatun and Hasina Khatun, went to the district jail of Borpeta to meet my said younger brother at a time. They met my said brother and noticed that one fat young accused person who took his hand upon the soldier upon my said brother while he was returning back to the state place. After 3 hours, an information was received by our family member that he was declared dead in the premises of the district jail Borpeta. It is a fact that this district jailer Borpeta took an amount of rupees 60,000 from me for giving protection and nutritious food to the same, but instead of it, with the help of the said-handed accused person who resides in the district jail as a convicted one, murdered him tactfully. A case was lodged by me against the above noted accused person, for which a case was registered by the OC of Borpeta PS, White Borpeta case number so-and-so under so-and-so. That sir, as regards, as soon as the instant case was started, investigation by the eye of the same, and hence one accused, namely Afazuddin, was arrested by police of Borpeta PS and was kept under police custody. It is a mournful fact that unlawfully the said accused has been released after 2 days. He was not forwarded to court. That sir, as regards the recently the other accused persons have been released on pre-arrest bail by the Honorable High Court. So all the accused persons are jointly giving a bolded threat and towards us to kidnap, to commit murder of my family members along with me, and the accused Quddus Ali, Afazuddin, Jinnat Ali, Nazrul Islam, Badsha Mia are jointly gathered and making a pre-plan to commit any kind of offense towards us for which we are afraid of them. Thus, sir, as regards it is a fact that IO of the case is negligently investigating the instant case and does not want to proceed the same ahead. Moreover, in spite of vital evidence found in this case, most probably the IO of the same does not include the vital witnesses also in this instant case. Thus, as regards it is reliable fact that the case is wrongly registered under the section of the Indian Penal Code, which is to observe by your ample power. That, sir, as regards I am residing under the below poverty line, landed bread by day laborer, hence I have no any source to take shelter except you. Hence, your honor would be pleased to take shelter as taking legal action against the accused person, otherwise a bolded irreparable loss will meet to us. That as regards your honor would be pleased to issue an order directing the concerning authority to take legal action against the named accused persons and kindly be taken smooth action against the IO of the case. Wherefore, I would remain ever grateful to you. That's, sir, as regards the finding, no alternative way I am coming. So, my lord, she came to this. But
So
my-
by filing this, the complainant wants legal action against accused and smooth action against IO.
Yes, through the Police Accountability Commissioner. Now,
Mr. Mahmood,
nothing was
did
done.
you have any role in drafting this complaint?
no, nothing like that. It was at the time of filing the case, they brought this. There are so many
So we
mistakes.
wanted to find out what is the smooth action the complaint wants.
Actually, so many wrong drafting grammatical mistakes are there, but we are helpless because it is their document they have produced, and I cannot conceal that. And so now, kindly say, my lord, it is a pathetic matter. The Police Accountability Commission also did not take any proper action. We don't know why, but they are having this power. Then, my lord, again a letter was sent to the Superintendent of Police Barpeta. Kindly see page 37. The same thing, my lord. We also sought his intervention. They kindly interfere in Barpeta PS case number 2222. But SP also did not take, and our information is that additional SP of Barpeta PS, actually, my lord, this Firdous Ali and his companions, actually a very rich man, very rich man, and he took it as the prestige of his family that his daughter was kidnapped by a person, Hasibul Islam, who is a poor person. My lord, lordship is our now the love is blind, my lord. So that they could not realize. However, the SP did not take a step. Our information, our instruction is that additional SP is involved in this case. That is why SP did not take so much interest. Then lordship kindly see page 40. We again wrote to DC, Barpeta. Page 40. But with no action. Now, my lord, then we are compelled. Then AB, they filed the private accused person, private respondents here. They filed AB number so that is 43, and they got interim protection. And thereafter, my information is that they have got the absolute bail. They will get, because the police personnel are also involved with this case. That is our clear case. Now, my lord, when the police personnel are involved in this case, the present petitioner Saiful Islam is the brother of his Hasibul Islam. Now, even he has given up his address. He is living in another place. For the safety of my client, I am not disclosing that. Due to the fear of these private persons, he is not living in his earlier address. He is living in another place. I know that, but I cannot disclose because other party is here. So that is one aspect of the case. Other aspect of the case is this, my lord, when the police personnel's roles are highly doubtful, and where my brother committed suicide, we requested them, that is on record, that kindly take us to that place, but they did not allow us. Somehow, from
Where is the postmortem report?
Postmortem report, my lord, we could collect, that may be seen, page 52. And medical certificate is also there, page 51. But we do not believe that, my lord. We do not believe that. There might be like this Dorong district case, my lord. Dorong district case where the even SP is now absconding. This 80 garden, a very poor maid servant was killed by one.
That's all right. That's another case.
Like this is like that case.
No, Mr. Mahmood, you make out a case on fact. We will admit.
Yes.
You don't make out, we'll dismiss.
No,
What happens
yes.
here, there,
No.
we are not concerned.
No, yes, my lord,
This
that
is
is
the court of law. Your arguments will be appreciated if you can convince the court that there is something wrong. Just by alleging that police officer is involved, that kind of arguments.
No, my lord, a
You have to
person-
substantiate your argument.
Yes, I understand that. And definitely this is why also duty to satisfy your lordships. But a poor person like me, I am knocking the door of here and there, SP, DC, Police Accountability Commission. No person will come to these authorities for pleasure. That is,
Mr. Mahmood, a poor person, forget it. He has now got you as his legal advisor. So you now convince us, you are advising
yes.
him.
Now that is my submission that yes, I'm. Now, so far this postmortem report is concerned, my lord. As per postmortem report, my lord,
Yeah.
certificate, lordship, I am their certificate is there. That is page 46. Page 46. Certificate of completion of postmortem examination. Certificate that postmortem examination had been performed on the above noted dead body at the Department of Forensic Medicine of FAA Medical College, Barpeta on 3/10/21. After postmortem examination, the dead body is handed over to the escorting police personnel. The medical certificate of cause of death in phone number so will be issued to the legal guardian of the deceased on submission of this certificate in original. Now, even the lordship would kindly see, the dead body was taken to hospital, but we were not informed this matter. Now, body of the petitioner side were present, and the doctor is saying that it will be handed over to the legal guardian of the deceased. Then postmortem report now
Where
can
is the
see
opinion as regards death? Cause of death.
cause of death. My lord, I am correct.
Mr. Roy,
Lordship.
where is the opinion of the doctor as regards cause of death?
Yes, I am submitting. my lord.
Lordship, in the affidavit, Lordship, we have filed paragraph 6, Lordship.
No, we want to see the document. Affidavit will not do.
Lordship.
Page 49.
Yes. Just for 56. Cause of death, my lord, my read petition.
Page 56.
56. Here,
What is
Yes.
the cause of death?
opinion regarding cause of death is kept pending.
Oh, Mr. Mahmood, take your seat. You don't even understand. We are asking you, where is the cause of death? You are pointing out that the doctor says opinion is not given now. This kind of, yes, Mr. Roy, where is the cause of death?
Pending.
Page 49.
Page.
Page 49. Of their petition. With 6.
Page 49 of the writ petition.
6.
Page 49 of 6, let us see.
Item 2, item 1.
Where is the cause of death?
Madam, page 49. Top portion, madam. Copy which has been served to me, madam.
Page 49, top portion is cause of death,
Cause of death.
which is kept pending. That is the cause of death.
Immediate cause death, injury complication which cause death, not the mode of death, heart failure, anesthesia, etc.
According to you, that is the cause of death. Here it is written, cause of death is kept pending. It is not due to heart failure. According to you, that is the cause of death. Mr. Roy, satisfy us, or
Lordship.
the SP has to come with the doctor. We need to know what is happening.
Lordship. Lordship, as per affidavit, Lordship, it has written, Lordship, the inquest report and the postmortem report, no injuries were found other than the ligature mark. Also, the doctor who conducted the PM, I am reading, Lordship, affidavit filed in, no,
Mr. Roy.
Lordship, I
it's a
understand,
simple
Lordship.
Question, a person has admittedly died
Lordship,
in the custody of the jail authorities.
Lordship,
We want to know what is the cause of his death.
Lordship,
Show us that, or tell the police, the SP, the jailer, everyone to come and remain present, and they will have to convince us.
Lordship.
Otherwise, the court will direct FIR to be lodged against them. As simple as that. What option do we have?
Lordship, in the postmortem report, mark of ligature on the neck is given, Lordship.
All right, 10 minutes.
Lordship,
Give us the name of the SP, the
Lordship.
doctor, the jailer. All of them will have to appear personally.
Lordship,
It's this mockery of the system must stop. The time has come now. Everybody who is connected with it. A person dies inside the jail, he dies an unnatural death.
Lordship,
And even after a proceeding is filed, a read petition is lodged.
Hmm.
There is no cogent materials to indicate the cause of death. What is that you expect this court to do?
Lordship, give me 5 minutes time, Lordship, I'm coming
5
back,
minutes.
Lordship.
All the next matter, please.
Lordship.
And also give the name of all the persons. We'll direct them to appear personally with the records. They will have to convince us that it is not a case of murder.
Item 4.
Mr. Mahmood, we are not happy with the level of assistance here. Though we understand it's a serious case, please be precise. Otherwise, the court will be compelled to appoint an amicus curiae. Yes, after 10 minutes, we'll take up.
No, this is also my item.
After
think-
10
I think-
minutes. this
No,
is
no,
also your-
item 4 is a separate item.
Okay, today is your day, huh? What is this?
Here is also a case, my lord, that is Bijni in Sirine district, my lord.
Hmm,
Yesterday I argued the case. One Abdul Khalik was killed while he was in police custody,
hmm.
and his parents has filed this writ petition seeking compensation. So our prayer is that the learned district and session judge at Chirang should be directed to investigate the matter and to submit a report, and on the basis of that, lordship may dispose of the matter. Because they say that he tried to snatch the pistol of SDPO,
Hmm.
which is totally impossible because 50 police personnel were there and he was handcuffed from the backside. So it is a totally contradictory story. And our prayer is that lordship may kindly see page
Yes.
12 and 13. It starts from page 11 bottom. To show as to why the encounter of Khalek Ali, that is Abdul Khalik also,
Hmm.
in the custody of police shall not be declared as illegal and unconstitutional, and also to fix responsibility upon the police personnel who are directly involved in the so-called encounter of Kader Ali alias Abdul Kader. So it will be Khalek, my lord, it will be Khalek. I am extremely sorry. On 8/7/21 at 12 midnight, while he was taken to the place of occurrence where the deceased Iyad Ali was killed, and to start appropriate legal action against the erring police officers, and or to show the justify a sum of rupees 25 lakhs shall not be provided to the petitioners as compensation and causes being shown. So, my lord, that is two prayers to fix responsibility upon the police officers who are involved in this fake encounter, and secondly, to pay us rupees 25 lakhs as compensation, because he was only our son and we was totally dependent upon him. But he has been killed by police in an illegal manner without.
When did the incident happen?
Incident happened, my lord. Incident happened on 8/7/21.
87 or 77?
That is. So, my lord, 8/7 will be because.
At what time?
After midnight, so it will be 8/7 or 7/7. Both the dates are correct. 7/7/21 and 8/7/21 in between. During the midnight. So he was killed when he was under the police custody, and the executive magistrate who deposed before in the case, my lord, he said that at that time there were 45 to 50 police personnel. So 45 to 50 police personnel, it is the prosecution witness says. Now question is this, is it possible for a person who was in police custody for nearly 2 days in Bijni police station among so many police personnel and other high ranking officers, and he was
So, who has appeared for the respondents?
It will be the government, my lord. Only the government party is the here, my lord. The respondents all are government officers. And one person, Ranjit Arfa, inspector of police station, police come investigating officer of Bijni police station. So he is by name, but he is also by dint of his designation.
So nobody is there from the government side. Yes, Mr. Nath. Are you appearing in item 4? Person killed in police encounter seeking compensation, 25 lakhs.
Malad, we have filed affidavit, our affidavit, Malad. The inquiry report and all, we have annexed. The magistrate inquiry report is also there, Malad. Kindly take our affidavit in opposition, Malad.
So today what is to be done?
No, we have also replied. We have held their
What is
affidavit
to be done
opposition.
today? We'll admit, post it for final hearing.
Yes, yes. Malad.
Huh?
Will be done.
Heard Mr. M. Mahmood
Yes,
Lanet,
yes, yes.
counsel appearing for the writ petitioner, also heard Mr. D. Nath, Lanet, senior government advocate Assam, appearing for the respondent numbers 1 to 4. Who has appeared for respondent number 5?
5, Malad.
Notice served.
Notice
Notice has been served on respondent number 5.
I don't know. Yes, Karban file ke diya. Karban file ke diya. Forensic report is issued, no?
Some report submitted by the respondent number 5,
Possibly,
possibly.
5 is Malad, is a private party. For.
Where is the report of the respondent number 5?
But the respondent number 5 was the IO in Disney PS case number 299 of 2021. In paragraph 3, they have stated.
The office note says that a show cause report has been furnished by the respondent number 5. Ranjit Rajkwa,
That
Inspector of Police. Disney Police Station, and the same is tagged with the record.
possibly he has directly given.
A report of-
Amag diya hai.
Not found any such report by me,
We have not received.
not received.
There is a report dated 20 April 2022. We have not got it.
No, I have not. Even it is not with them also.
This is PM report. Pending.
My lord, may I do one attention of your lordships, kindly see page 60 of our affidavit.
Just a minute, we are going through the report. Report person. 20th of April 2022.
Yes, sir.
There is a magistral inquiry report and there is a report submitted by respondent number 5.
Malad.
Have you received both the reports?
No, magisterial inquiry report, we have annexed in the affidavit.
Hmm.
That report is not with us, no?
All right, just let us go through the report. I think it is only there in this.
Not. IO's report is not with us. Your worship. One more. मुन्नी तक वो दिखा One and two.
All right, then let the report be circulated.
Lordship.
Then after that, we'll take up,
Malad.
because in the report, some very significant revelations have been made. It seems the person who has murdered the victim has been identified. That is what prima facie appears.
Lordship.
All right,
The magistrate inquiry report is annexure A to our
that is there.
lordship.
Heard Mr. M. Mohammed, learned counsel appearing for the petitioner, also there. D. Nath, Menon, senior government advocate, also appearing for respond number 124 system. Upon receipt of notice, the respond number 5, that is the inspector of police, Bijni Police Station, has not entered appearance, but has sent a report dated 20/4/2022, which is available on record. However, the learned counsel for both the sides have not been furnished with the copy of the report, nor is the same tagged in the second judge's file of this case, as a result of which the parties are unable to, parties are unaware about the contents of the report. After going through the report dated 20/4/2022, this court is of the opinion that the disclosures made therein would have a relevant bearing in the outcome of this proceeding. Mr. Register to therefore furnish copy of the report dated 20/4/2022 to both the parties, and also tag a copy of the same in the second judge's file. First of all, let the matter be listed again after 3 weeks. Let it be listed up.
Lordship.
You go through the report,
Yes.
file your response.
Time being letter, I just put it through.
Yes, you are
Malad.
appearing now.
Yes, Malad, I'm appearing.
Where is the postmortem cause of death?
Postmortem report is annexed in the
There, but
affidavit.
where is the cause of death?
Cause of that in the, it was at that point of time awaited because of the FSL report. FSL report we have annexed in the affidavit filed later on, my lord. It is page 101, running page 101 is the affidavit.
This is WPC number.
WP criminal 6/22. Now the FSL report has come.
But where is the medical opinion about the cause of death?
106, page 106. Relevant is 106.
Yes,
Running page 106.
yes. Oh, which part?
Last page. Ma'am. Yes. Running, running page. Running page.
106.
Yes, the last sentence, I would like to inform you that, in my opinion, the cause of death, so and so, death was due to antemortem hanging, which was suicidal in nature.
Yep, just give me the file. Can you please flag mark it?
Yes, yes.
And you can keep a video like this. First video 8/4, na? Space mark, just size it. 8/4. I will reply this.
Probably it is 116.
Lordship.
Page 116 or 106.
Now it's.
It was first written, it was 106, but it was erased and now it is written as 112.
112.
112.
Here it is 116. Anyway,
Lordship.
please give it to us.
Lordship. Last affidavit comes out. Last.
Everything
Last
for us.
affidavit. ये बताओ बस.
Fill the record.
Affidavit because whether reply this and reply not reply to reply Monday Tuesday मैंने रखे दिया. 511 or affidavit. Amitabh Sinha affidavit is out. FSL report.
Ah, yes.
Hey one. From a mark side ये तो अपना. क्या पहले तो
All right, so as for the FSL, as for the postmortem report,
Malad.
that was due to hanging,
hanging.
antemortem hanging.
Antibody hanging and no poison was found. Malad, kindly come to the previous page. It starts at page, Malad, in my copy, it is 104, possibly. The next page, result of examination, ultimately those viscera and all those were examined,
That's all right. Viscera, no poison found. Yes.
no poison
toxic-
found and ultimately the result is.
Viscera test is only for ascertaining toxicity.
Yes, no poison.
All right. So this copy you have brought on record by filing affidavit
Yes,
on
but we filed the affidavit.
10th November 2022.
Yes, sir.
Is it?
Yes, 10/11, Malad.
10/11.
We filed on 10/11/22.
All right. So Mr. Mahmood, have you filed any reply to this?
10/11.
You are not aware of the affidavit.
No, we have given.
10/11, you see, it is one is 25, 20.
No, we are asking about 10/11 affidavit
10/11
filed
we
by
have
respondent
not
number
found.
3. You have not received.
10/11 we have not. We have found 3 affidavits. It is 25/3.
No, most ideas. Malad, we have served him. If necessary, I'll give again, Malad.
There is one affidavit filed on 12th September 2022.
Lordship.
Have you received copy of that?
No,
No.
no.
How was it filed without serving copy?
The notice is there, Malad. Copy has been served. Service of proof of service is there.
We have received 3 affidavits.
Yes,
One
we
is
have filed three.
25/3, 22, 8/4/22 and 25/22. So that's perhaps it was filed either earlier or later, it may be. But as per our receiving that, it does not permit.
It does not contain anybody's signature in receipt.
Not, I'll serve a copy, Malad.
Which are the affidavits? One is dated 22.
My file 2025/3/2022 by respondent number 3.
Wait a minute, one by one. How many affidavits?
3 affidavits.
What are the dates?
One is 25/3/2022
Yes, we have found.
by respondent number 3.
What is
Yeah.
that?
Next is 8/4/2022
Yes, that also. we have.
by respondent number 5.
Yes.
And last is 10/11/2022 by respondent number 3.
Another affidavit is filed by Ranjit Bayon.
What about the affidavit filed by Sanjeev Kumar Chetia?
Sanjeev Kumar Chetia is respondent of, it is a 5, Malad, respondent number 5.
We find there is an affidavit filed on 12th of September 2022. Who has filed that?
Malad, that is the deponent is Ranjit Bayan, Malad.
No, it is not Ranjit Bayan. It's
Sandeep Chetia तो एक नहीं है. एक If an alternately filed was second September. But in fact, the affidavit which I have said on 8/4/22, but possibly there was some defect. It was erased and again it was refiled on 2nd of September. 12th of September. I stand corrected.
So have you received, Mr. Mahmood, have you received the copy of all these three affidavits?
Three affidavits you have got, that is 25/3/22,
Hmm.
and then 8/4/22,
Hmm.
and then 10, 20, 5/22. It is by Ranjit Bayo. That is respondent
Last
number.
affidavit, he has not received. Lord. I'll serve a copy. Lord. Today itself I'll serve. But this 8/4 may be corrected as 12/9 because I have from the record I have checked out.
So you give him a copy
I'll give him. Today I'll give him.
and you have to tell us why this opinion is not acceptable. Merely by saying it is not possible, it is not possible.
No, we
That-
have filed an.
that will not be
affidavit
enough.
to discuss of that case. Very well, yes, we will file counter, my lord. As soon as I get, I will definitely go through all this and then file reply.
Item 6. Mr. Anu, Senate Council for the petitioner submits that no copy of the affidavit dated 10/11/2022 filed on behalf of the respondent number 3 has been served upon him. Mr. D. Nath, Leonard, senior government advocate, appearing for the official respondents, submit that the copy will be furnished to Mr. Mahmood within 2 days from today. In view of the above, let this matter be discussed among 3 days, along with WP criminal bracket close number 01, 2022. So as to enable Mr. Mahmood to seek instruction and file rejoinder if so advised. You examine and tell us what is wrong with the medical postmortem report. Otherwise, it will be difficult. Extraneous facts will not have any.
No, our High Court has also some decisions on this point.
Cases are all on facts. 2 cases of similar nature, one will be allowed, one will be dismissed. It will depend on the facts. It's not that every case of custodial death, we have to go against the officer. That's not the law. You have to make out a case on facts. Doctor says the death is due to anti-mortem hanging. That opinion is given after awaiting the FSL report on viscera test, etc. What is wrong with that report and why the court should not accept this report? You have to point it out to us. If you cannot, then we'll close the matter on the next.
Now,
day.
one thing, my lord, there are cases that he committed suicide in the latrine.
Hmm.
If your lordship kindly send on commissioner or any other high ranking officer, it is completely impossible. Because so many persons are there, everybody will look, his head is always visible from outside. So, my lord, everything is for the ends of justice. Substantial justice should be provided. The state authorities cannot be allowed to take the advantage of their own mistakes.
Respond to this argument of the next day.
Well, let him file the affidavit. We'll
Affidavit some postmortem report,
Yes.
but he is saying the latrine is such
Lordship.
that it is not fully covered. There is no way one can hang oneself in that place because the upper part of it is exposed and it will be seen by everybody else. That's what he is saying.
Lordship.
What do you have to say on that?
Well, without instructions, I can't
So you
because I
open
have to verify or in the affidavit in reply, he can also point it out, my lord. It's a
But
factual thing. my lord.
is this your pleaded stand in the?
Yes,
petition?
yes. Yes.
Then so
I'll-
if you don't have instruction, we can't help.
No, the detailed facts and the report we have already annexed. Lord. And on that basis, it can be done in that case, it has to be verified. Otherwise, how it has happened, we have already stated in response to what he has said in the writ petition.
All right, we'll see.
Lordship.
Thanks to-
And CCTV camera of that day, when I was compelled to pay rupees 60,000 to this private respondent, Ranjit Bayan, for the security of my brother, it is will be also visible. So CCTV camera of that day may be also asked to produce.
So have you lodged any FIR to that effect?
This thing, on that count, because that case, one case will be sufficient. As an,
Your opinion, but your opinion will not be of that.
no,
important.
actually, these things came to us later on that
No,
police.
without a
personnel-
formal complaint, how the court will take cognizance of these things?
But Lordship.
That is why, my prayer was that the London District and Session Judge at Chirang may be asked to conduct an inquiry.
Inquiry on what?
Inquiry into how the death occurred to this Hasibul Islam and what are the,
We'll do it. If a case is made out, we'll do it.
yes.
If it is
Yes,
not
sir.
made out, then the question
Definitely, I
doesn't-
will satisfy you.
Lordship. Lordship.
Yes.
Item 5.
Sorry, my lord, one thing, my lord. Abdul Khalek name is wrongly written last part, Abdul Kader. Kindly allow me to correct it. It will be Abdul Khalek, not Abdul Kader. Last, in the prayer portion, Abdul Khalek's names has been recorded as Abdul Kader.
We'll see. Right now, orally, these things we are not getting into.
If your lordship kindly allow me, I correct it.
That's not permissible. We'll not-
I don't know.
We'll
what-
see. That will not come in your way. Yes, yes. What is the matter?
Made, please your lordship. My lord, this is also a case of extrajudicial killing of the two sons of the petition number 1 and brothers of petition number 2. And here in this case, my lord, notice of motion was issued and the landed
Extrajudicial killing by whom?
by the police, my lord.
Acha, under what circumstances?
Circumstances is this, my lord, on 13th of April, 2022, my lord, the respondent number 8 filed an application before the CGM Gusaigaon for production of these two killed persons, my lord, because they were arrested in UP. They were arrested in UP and they were detained in jail in Mirat. And therefore, an application has been filed by the respondent number 8 before the CGM Gusaigaon for their production. And accordingly, an order has been issued on 13th of April. And on the same very day, these two persons who were killed, they were brought out from the jail of the Mirat. And they were produced on 15th after one day, my lord. The application was filed on 13th, order was procured on that day. On the same day, they were procured from the Mirat. And my lord, on 15th, my lord, they were produced before the CGM Gusaigaon. And on that day, an application has been filed for custody, police custody for 14 days. And that was objected. And in spite of that, 7 days custody was given. 7 days custody was given. Then on 18th of, after 3 days, my lord, 18th of April, it says by the respondent number 8, that respondent number 8, along with the police officers, police personnel, taking these two accused persons, went to a particular place to look out the hideout of some cattle trader. And along with the fact that there were some camps of some extremist group in Shonkur's River in Gusaigaon under BTAD area. And accordingly, along with these two accused, the police personnel went to that place. And while they were going there, then there was an ambush. And in that ambush, the fire were exchanged taking place where these two persons were killed. And then this is how the incident was taking place. That was their explanation.
Ambushed by the extremists.
Extremists. They said an extremist. And here in this case, my lord, at the outset, I want to point out one thing, that all the respondents are represented except 8. And 8 is the main person, my lord, who made an application, who got the production report, who produced these two persons, and who sought for the custody of the persons, and who has taken this custody of this person, went to that place, extremist camp, and there was an exchange of fire. All these things, my lord, within the knowledge of the respondent number 8. And respondent number 8 has been served. And notice, my lord, office note says that on 21/7/22, notice was sent. And office note dated 12/8/22, it says, my lord, neither AD card, nothing of the or answer notice has been received back. Now, my lord, this is one of the facts that I'm telling to your lordship. Then our prayer before this honorable court is these things. The number one, to cause a judicial inquiry into the accident, actually what really happened, how these two persons, two sons of the petitioner have been killed. Number one, and number two, while even after killing these two persons, the notice has been sent to the petitioner, who is the father of these two persons, and brother, to appear before the said IO, that is number 8, that you also come here in Gusaigao, BTAD. So under their circumstances, my lord, this father, the petitioner number 1 and 2, father and the brother, they, my lord, filed an application before Supreme Court, the Honorable Supreme Court, and the Honorable Supreme Court passed an order saying that this matter is very urgent. Though Honorable Guwahati High Court will be taken look into the
Where
matter.
is the order? Where is the order?
My lord, page 51, my lord. And type copy I have given, my lord, 49. That petition was withdrawn because of the fact that the incident was taken place within Assam. And photocopy 51, my lord.
For a period of how many days? No coercive action shall be taken
My
against
lord.
him for
My
a
lord.
period of.
It is continuing. It is subsequently, my lord. Subsequently, when we have
This honorable court has.
this honorable court has given the
protected.
that protection, my lord. This is how, my lord, we are before your lordship, father and the son.
All right, so today, what is to be done? This has come for,
Number one, my lord, the presence of person number 8 is also because he is the main person, my lord.
all right, if it doesn't come, we'll, if necessary, we'll pass orders against him. That can't be the service of notice is deemed to be complete on respond number 8. We'll take
Fine.
it that way. Which is the office note dated?
Office note, my lord, dated 12/8/22, my lord. 21/7 and 12/8. Otherwise, my lord, the SP has filed an affidavit.
No, where is the office note regarding services notice upon respond number 8?
My lord, 12/8/22, my lord. 12/8/22, last office note, my lord.
12/8/22. There is nothing on respond number 8.
Is written, my lord, 21/7/22, respond number 8 is written. 21/7/22. Others are represented, my lord. My learned friend is appearing for other respond.
Notice was issued on 21/7/2022. And the 12/8 says neither ID card nor
My lord,
service.
my lord.
So
That's why, my lord. My lord, my lord, may I pray in this way, my lord? Since the SP is representing, SP has already filed an affidavit, my lord. And SP of the concerned district, my lord. So, my lord, a fresh notice can be sent to him through my lord SP. Otherwise, he will avoid it. He's the main person, he's avoiding, my lord. And we also don't know his office, the home address, we don't know. And he's the main person, my lord.
He wants to serve notice on respondent number 8.
But SP will assist if he is not transferred in the district, definitely SP will give him. I don't know Malad, whether he is in that particular place as on today or not.
And my lord, we can also find out if he has been
Or
transferred.
it will either
by
submit if he is still serving in Kokrajhar or transmit it to the concerned SP in whose jurisdiction the respondent number 8 is serving.
Lordship, through SP, I can verify Malad, where he is now. Right at this moment, Malad, I don't know. Through SP, I can. verify.
What is the stand of the
Lord.
SP in the affidavit respondent number 3?
Malad, we have filed an affidavit, Malad, the kindly para 7 is a long paragraph, Malad. I will take your lordship to relevant internal page 8, Malad. Sorry, 4. Page 4. Malad, 11 lines from bottom. The sentence starts as on receipt of instruction. Has a lordship got Malad? On receipt of
11 line from bottom, yes.
On receipt of instruction, the respondent number 8 proceed towards the area as disclosed by the accused persons after ensuring ample protection like safety measures such as bulletproof jackets for all including accused persons, sufficient armed forces with vehicles. The respondent number 8 was also directed to inform the respondent number 6 for that for instant support. But the respondent number 8 along with the respondent number 6 staff of Saraibil BOP and arrested accused persons in police custody were proceeding towards the area as disclosed by the accused persons, namely Akbar Banjara and Salman Banjara, at about 1:15 a.m. dated 19/4/2022. The vehicle of the police party came under sudden ambush by extremists near Jamduar forest, and immediately the police team got down from the vehicle and took lying positions and started firing back towards extremist side. But the above named accused persons could not get down from the vehicle and sustained bullet injuries. The firing between extremists and police party lasted for about 10 to 12 minutes. And when the firing was stopped totally and after sensing no danger, the police party immediately evacuated the injured accused persons from the vehicle and sent them to Saraibil Model Hospital, and medical officer declared them brought there. Under that circumstances, they died. The remaining police personnel who were injured in the said incident of exchange of fire were taken to the Saraibil Model Hospital. It is pertinent to mention herein that the remaining police party cordoned the area and searched the place of occurrence. And after some time, one AK-47 rifle, 2 magazines, and 35 rounds of live ammunition of AK-47 rifle and 28 rounds of fired empty cases of AK-47 rifle were found at place of occurrence, which were seized accordingly at the place of occurrence, along with one tree which was put across the road for blocking the vehicle. And as the vehicle bearing registration number AS 16F4104 got damaged due to bullet firing, the same was seized in non-functioning condition there. After that, as the respondent number 8 got severe injuries in his both hands and chest as bullet was hit in his bulletproof jacket, and he was also got admitted in the same hospital in Saraibil for treatment, where he was informed by on-duty medical officer that the arrested accused persons were brought there. It is also to be noted that at the time of firing, the respondent number 8 instantly tried to inform the respondent number 3 and the police control room for reinforcement and for help, but due to unavailability of mobile network, he could not contact them from the spot.
So respondent number 8 was also injured.
He was also injured.
He is the main, my lord. He is the main person, my lord. He is the main person, my
No,
lord.
main person means what do you mean by main person?
He was the IO.
He was doing
Because-
his duty.
Because that's right, my lord. That is why he is answerable to all these things, my
So
lord.
what answer do you want? What is that you want now in this petition?
Now, in this petition, my lord, we prayed that an impartial judicial inquiry is to be directed to find out the real cause of the killing of these 2 persons. Number 1. Number 2, to give safeguard to the family members of these 2 persons. Number 3, my lord, we have prayed that a strict action after finding inquiry, my lord. If he is guilty, then a strict action should be taken against this particular respondent number 8. And fourth, my lord, compensation. These are the.
No, Mr. Chaudhary, I don't know what my learned colleague will say. Save and accept your fourth player. We don't think you have anything else here. Because it's their case, straightforward case, that it was a case of ambush where the extremists had attacked the party.
My lord,
And the police also received bullet injuries.
my lord.
But they could not get down from the vehicle. Unfortunate, they were hit by bullets, they died. So therefore, what is there to be inquired against respondent number 8 personally? Do you say that he is a part of a conspiracy to kill them?
Yes, my lord.
How?
My
And
lord.
he will take bullet
No.
injuries himself.
No, my lord, your lordship will see, that he says, the respondent number 8 says that he got the information that the some extremist groups, namely KLO and my lord in the BT area, NDFB, camps were there. The camp of the extremist groups were there in that place. And in order to find out those extremists, my lord, he, along with some staffs, along with these 2 persons, went to that place in the O hour, 1:15 a.m. in the midnight. It means that a police officer should know that he is going to an extremist camp to find out, to arrest, or to look out, and therefore police should be prepared. That these kind of things, necessarily they will not offer fruits and all these things, my lord. They will offer bullet. And therefore, my lord, it is the duty of the police officer to take adequate police, my lord. Here it says, my lord, the affidavit lordship says that his mobile phone is not working. My lord, a group, my lord, where he is going to face the extremist group, knowing fully well. And that is his stand, my lord.
What is the reason for taking the 2 arrested persons to that place?
My lord, because they
Initially, my lord, an FIR has been lost.
the arrested accused persons in police custody were proceeding towards the area as disclosed by the accused persons, namely so and so and so. And so they possibly they have disclosed that there is some connection, and from there,
Therefore, what is stated in the affidavit? Why was it necessary to take them to that place at 1:15 at night? Knowing that it's an extremist infested.
if lordship, I have started from that particular sentence starts so on O on. Just in the middle, Malad, I'm reading from. They also disclose that they can show the secret road and temporary camps of extremist group and members involved with the smuggling of cattle. It is the information disclosed by them. That is why they were taken. On such revelation of facts, the authority concerned was informed about the developments, and on receipt of instruction, investigation proceeded further. Accordingly, on the same day, the accused persons were taken to Gosaigaon PS for more interrogation, and during interrogation, the accused persons disclosed same thing as disclosed in Kokrajhar PS, which was duly informed to the authority. Okay, I'm reading page 4. Page 4 of the exhibit. That is one lord.
That is why my respectful submission is this, my lord, that he got the information. The respondent number 8 has got the information.
They are truck drivers. They're running trucks, and in those trucks are used for smuggling cattle. They are smuggling cattle to Bangladesh. But they disclosed that the temporary camps in the jungle, and they know the routes. That is why they were also taken, because they have revealed that they had the knowledge of the roads and the places, my lord, where those exist. They are part of the smuggling racket of cattle, my lord. They are not innocent persons involved in some cases, and just they were taken by police on that day, my lord.
So what do you have to say on his prayer for service of notice upon the respondent number?
My lord, respondent number 8, my lord, I can very well verify from the SP whether this person is still working there or not. If he is working, SP will definitely cooperate.
Then first let him verify.
Yes,
We'll have it next week. Let him come up with
if
the
the respondent
answer.
number 8 is working there, but
Otherwise he'll be in person.
he was the IO. That is why they are alleging that he is the
Mr.
main
M.
person.
H.
He was the
Chaudhary,
IO.
senior counsel, appearing assisted by Mr. Huh? P. Chakraborty appearing in this case on behalf of the writ petitioners submits that all the respondents, save and except the respondent number 8, have entered appearance in this case. First of, however, since the respondent number 8 was the IO and the main person involved in the incident, and service of notice upon the said respondent would be necessary in this case. First up, from the office note dated, next paragraph, from the office note dated 21/7/2022, we find that notice by registered post with AD was served upon, was sent for service upon respondent number 8. But as per office note dated 12/8/2022, neither AD card nor any service report is available. Full stop. Be that as it may. Taking note of the request of Mr. Chaudhary that the respondent number 8 can be served through the jurisdictional SP. We grant 7 days time to Mr. Nath to seek instruction as to whether the respondent number 8 is still serving in the Kokrajhar district, and if not, the place of his present posting. First of, let him come up with that, then we'll pass an order.
Highly. Malad has given a date. Malad, in this case.
List again after 7 days.
7 days. Malad.
For hearing on our matter, I think that-
May I please, your lordship?
Mr. Mahajan, give us a brief recapitulation of your arguments.
Lordship, on the last occasion, lordship, we went through the evidence, my lord. Conviction in this case is primarily on the basis of PW5, my lord. The prosecution claims that he's the solitary eyewitness, my lord. He's the son of the deceased, my lord. Lordship, on the last day had asked a question whether conviction on his sole testimony can be sustained, my lord. My lord, yes, my lord, conviction on the sole testimony eyewitness is definitely sustainable, my lord. But my submission as to why his testimony is unreliable, my lord, makes him unreliable, my lord, is that his conduct, my lord. The appellant is known to the prosecution witness, my lord, PW5, my lord. They are immediately members of the same family, my lord. There's some land dispute and everything going on between them, my lord, and previous cases have filed between them, my lord. He sees his father getting beaten up with only a stick or a lathi, my lord. He does not go to help his father, my lord. He has not sustained any injuries in the incident, my lord. That is one submission, my lord. The second submission is that, my lord, the FIR was allegedly lodged on, my lord, 26/10/2006, my lord. However, the FIR was only sent to the magistrate, my lord.
FIR was lodged on 26.
26/10/2006, my lord. However, the FIR was only sent to the magistrate on 30th, my lord.
Sent to magistrate by whom?
By the police, my lord, investigating officer, my lord. On 38th, my lord. It's there in the record, my lord. The magistrate's signature is at 38th scene, my lord. So after a period of 4 days, my lord.
So was it sent on 30th or the magistrate signed on 30th?
My lord, as soon as the FIR is received, my lord, the magistrate signs it, my lord.
The question is, was the FIR sent on 30th or did the magistrate sign it on 30th?
That is not there, my lord. I could not find it, my lord. I only,
But that is relevant.
I only saw the, my lord, the scene copy of the FIR, my lord, the original copy, my lord. Scene 30th, my lord. So after a period of 4 days, my lord. On the last occasion, I placed a judgment, my lord. The delay in dispatching the FIR, my lord, it has to be forthwith, my lord, as per 157 CRPC, my lord. If there is delay, my lord, it may lead to a idea, my lord, that the
Let us
FI
see where it is.
it's in the LCM.
Give it to him. Give it to him, and Mr. Mahajan, can you please flag the 161 statement of PW1 informant and PW5? We'll
I
come
will
back in 5-7 minutes
I
after a
will-
brief. We'll finish off this matter. You are ready? Just wanted to see the 161 statement and
So, my lord, last occasion I placed a judgment, my lord, 1994 5 SCC, my lord, 188, my lord.
you have relied upon 1994 5 SCC.
5 SCC 188.
For which, on which point?
2 points, my lord, that the FI being anti-time, my lord. And the unnatural conduct of the son, my lord, PW5, my lord. Paragraph 12, my lord.
Paragraph 12 is regarding lodging of FIR. FIR was lodged here promptly.
Lost here probably, my lord, but
Ah. What
And-
is the, we have
and-
not understood. Supposing the magistrate does not sign it today and sign it after 2 days,
my lord.
that means the prosecution case will fail.
No, my lord, but it may lead to an inference, my lord, that the FI was anti-time, my lord, that what the prosecution says, my lord, that the FI was lodged today, my lord, possibly it may not have been lodged today, my lord. That is what this, it says, my lord. May I read, my lord?
Hmm.
This is paragraph 12, my lord, 10th line from the top, my lord. With a view to determine whether the FI was lodged.
Hmm.
With a view to determine whether the FI was lodged at the time it is alleged to have been recorded, the courts generally look for certain external checks. One of the checks is the receipt of the copy of the FI called a special report in a murder case by the local magistrate. If this report is received by the magistrate late, it can give rise to an inference that the FI was not lodged at the time it is alleged to have been recorded, unless, of course, the prosecution can offer a satisfactory explanation for the delay in dispatching or receipt of the FIR by the local magistrate. The prosecution has led no evidence at all in this behalf. The second external check, the sending of the copy of the FIR along the dead body and its reference in the inquest report. Even though the inquest report prepared under section 174 CRPC is aimed at serving a statutory function to lend credence to prosecution case, the details of the FIR and the gist of statements recorded during the inquest proceedings get reflected in the report. This is what I'm relying upon, my lord. The absence of those details, my lord, that the FI was not sent on time, my lord, is indicative of the fact that the prosecution story was still in an embryo state and had not been given any shape and was then anti-time to give it the color of a promptly lodged FI. In our opinion, on account of the informant notice, the FI has lost its value. And then on the conduct, my lord, para 13, my lord, it appears that it was a blind murder and none of the eyewitnesses were actually present at the scene. The anti-timing of the FI was obviously made to introduce eyewitnesses to support the prosecution case. We may demonstrate this by noticing that though PW3 Srimati Kamlesh, the widow of the deceased, claimed that she was present with her husband at the time of the occurrence, her conduct was so unnatural that not only she did not try to save her husband by trying to provide a cover, but even after her husband fell down and was inflicted repeated injuries with the knife by the appellant Mehraj, she did not even try to go anywhere near her husband, even later on, hold his head in her lap and try to provide some comfort to him. She admitted that she has not even received a scratch during the occurrence. In a situation like this, a normal conduct of any wife would be firstly to make an effort to save her husband, even by taking the blow on herself. And if that is not possible, then at least to go so close to this person, at least after the assailants had left, that there would be no escape from the blood oozing out of the injuries of the deceased to come onto her clothes. But here in our case, my lord, in the present case, my lord, what you kindly appreciate, my lord, everybody's house is nearby, my lord. It is not that it's an isolated place, my lord. The incident where it occurs, my lord, is directly close, adjacent to my lord PW2's house, my lord, who's family member of these the deceased, my lord. It's not that it was a strange new place, my lord. And the assailants, as per the prosecution, my lord, were known to the boy, my lord, PW5, my lord. In that scenario, my lord, it becomes more unnatural, my lord. He did not try to save his father, my lord. He did not even go in to save his father, my lord.
Why do you say, try to say?
Now, may I read his 160, my lord? মোৰ নাম দিগেন চৌধুৰী মই হাইস্কুলত পঢ়ি আছো আজি ইমান তাৰিখে গধূলি অনুমান 9:30 মান বজাত মই মোৰ দেউতাৰ লগত আমাৰ গাঁৱৰে শ্ৰী সন্তেশ্বৰ চৌধুৰী ঘৰৰ পৰা আহি থাকাত অৱস্থাত শ্ৰী জয়ৰাম চৌধুৰী 3 ফুট মান দীঘল লাঠিৰে শ্ৰীযুত শ্ৰী ফটিক চৌধুৰী ঘৰৰ সন্মুখত মোৰ দেউতাক মূৰত কোবাই কিছু দূৰত জয়ৰাম চৌধুৰীৰ ল'ৰা শ্ৰী কমল চৌধুৰী চাই আছিল এতিয়া দেউতাৰ গুৰুতৰভাৱে আঘাত হয় পিছত শ্ৰী জয়ৰাম চৌধুৰী মোক মাৰিবলৈ হয় আৰু মই চিঞৰ বাখৰ কৰোঁ মোৰ চিঞৰত শ্ৰী ফটিক চৌধুৰীৰ পৰিয়াল লোক ওলাই অহাত শ্ৰী জয়ৰাম চৌধুৰী উক্ত স্থানৰ পৰা পলাই যায় and then my lord in depot
What is unnatural in this?
my lord in one this is he says one blow he screams and they run away my lord in then deposition my lord he says my lord
One blow, who said one blow?
here my lord কেৱল লাঠিৰে শ্ৰী ফটিক চৌধুৰীৰ ঘৰৰ সন্মুখত মোৰ দেউতাক মূৰত কোবাই কিছু দূৰত জয়ৰাম চৌধুৰীৰ ল'ৰা শ্ৰী কমল চৌধুৰী চাই আছিল এতিয়া দেউতা গুৰুতৰভাৱে আঘাত হয়
Yeah, one blow, he doesn't say one blow, he says
কোবাই
he was hit in the head.
কোবাই হাইস্কুল
Yes.
but he does not go to
In 161, he need not give graphic details of
my lord
how many hits, how many strikes.
my lord and then he says my lord that the appellant's son is watching from a distance all of that my lord in deposition he says that both the appellant and the son beat the deceased my lord he screams my lord
So therefore, Mr. Mahajan, what is your submission on that? You tell us, we'll note it down.
my submission is only this my lord
Hmm.
his conduct makes his testimony unreliable my lord.
Okay, that we have already said.
His unnatural conduct yes my lord that my lord
Then the second is magistrate signs the FIR belatedly after
Immediately,
3 days.
my lord after yes my lord. Those two my lord it makes it seem my lord that the as per the judgment my lord that the eyewitness was planted my lord to make out the case my lord.
So you think it is a case for acquittal?
Love, I'm arguing as for acquittal my lord.
Huh?
I'm arguing for acquittal my lord.
You're arguing for acquittal. Let us see what is the finding of the trial court and which part you find is not agreeable. Remember,
Page 74 my lord.
yes, relevant part, we'll start from the relevant part.
Yes my lord.
Yes.
Page 74 my lord, second para my lord. It is seen that PW5 is the only sterling witness who had seen the entire crime being committed by the accused persons with his own eyes. The evidence so adduced is found to be cogent and reliable and clear, then conviction can be based on a single witness. The evidence adduced by PW5 is corroborated by the evidence adduced by the MO on all vital points. The medical evidence of the MO, that is PW3, has corroborated the injuries sustained by the deceased. The other PWs have all corroborated the injuries seen by them on the person of the deceased, though have not seen the occurrence.
Yes.
Then my lord, page 76 my lord, second para. It is seen from the evidence of the sterling witness PW5 that both the accused Joyram and his son were together, and initially Joyram inflicted the blow with bamboo stick on the victim deceased. Thereafter, both accused persons gave several blows on the chest and the stomach of the victim deceased. According to the postmortem report, the deceased had several injuries on his chest. Hence, the wounds of the deceased are attributable to the accused Joyram and the co-accused Kamal, who never stopped the accused Joyram when he was inflicting the wounds to the victim deceased and thereby facilitate the commission of the crime. Hence, both the accused can be fastened with liability to common intention. Primarily committed PW5, my lord. In 161, my lord, again I'm saying, my lord, he says Murad Kubai is my lord. In deposition, my lord, he says, my lord, on the head and chest to match the postmortem report, my lord. That was another submission of mine, my lord, that he improves his story to match the report, my lord. Because had he been actually been there, my lord, he would have seen, my lord, his father getting beat up on the head. And
But even the PW1, if I remember correctly, had said that she had seen just
Yes, Your Lordship.
no, my lord, that
PW1 has also seen.
yes, my lord, but that is broken in cross, my lord.
Which page?
Cross of PW1 is at page, my lord. The contradiction, my lord, page 40, my lord.
Page 40.
40, my lord. The IO, my lord. Well, PW1.
Page 10 of PW1.
No, in page 10,
Yes.
PW1 says,
6th line, my lord.
I came out and saw that Jairam and Kamal Chaudhary were beating my husband. She is also an eyewitness.
My lord. This is what she says in the chief, my lord. In the IO's cross, my lord, page 40, my lord, last line.
Did she say so in a 161?
Page.
Page 40, my lord. Last line, my lord. Witness Subhan Chaudhary did not state before me that she had seen the accused persons assaulting her husband. She had not seen the occurrence, my lord. Although she says in the
But
chief.
let us see what is there in your 161.
Mary. Mary,
Yes,
Your
yes,
Lordship.
সোহন চৌধুৰী মোৰ নাম শ্ৰীমতী সোহন চৌধুৰী মই দত্ত চৌধুৰীৰ পত্নী হয় আজি গধূলি 9:30 বজাত মোৰ স্বামী আৰু ল'ৰা দিগেন চৌধুৰী গাঁৱৰে খন্তেক ঘৰৰ পৰা আহি থকা অৱস্থাত আগতে চুপ লৈ থকা জয়ৰাম চৌধুৰী আৰু পুতেক কমল চৌধুৰীয়ে মোৰ স্বামীক বাঁহৰ লাঠিৰে ফটিক খুৰাৰ নঙলা মুখতে ফটিক চৌধুৰী one of the witness মুখতে খুজাৰে কব মাৰি দিয়ে কি পঢ়ে হৈ পৰে দিগেনে চিঞৰ বাখৰ কৰাত মই লগতে ওচৰ চুবুৰীয়া ওলাই আহো আৰু মোৰ স্বামীক আহত অৱস্থাত ৰঙিয়া চিএইচিত থানাৰ যোগে চিকিৎসাৰ বাবে লৈ যোৱা হয় যদিও চিএইচিত তেওঁৰ মৃত্যু হয়
She did not see the.
As per her, she comes out when he screams for PW.
Lordship, the residents of the PWs in close vicinity, Your
No,
Lordship.
that's another matter.
Yes.
But did she say before the IO that she had seen them beating? As she has deposed before the court. That statement is not. there.
Lordship, আগতে চুপ লৈ থকা জয়ৰাম চৌধুৰী আৰু পুতেক কমল চৌধুৰীয়ে মোৰ স্বামীক বাঁহৰ লাঠিৰে ফটিক খুৰাৰ নঙলাৰ মুখতে জোৰেৰে গবা something is written, no, she could not understand, মাৰি দিয়ে মাত হৈ পৰে দিগেনে চিঞৰ বাখৰ কৰাত মই লগতে ওচৰ চুবুৰীয়া ওলাই আহো আৰু মোৰ স্বামীক আহত অৱস্থাত ৰঙিয়া চিএইচি
That's what we are saying.
So, Lordship, there are two parts here, Lordship. The PW5, the witness who was with the deceased, my lord, he saw beating, Your Lordship. Then he made hue and cry. That time, other witnesses have come out, Your Lordship, and they saw the accused person running. And this witness said this: she saw them beating up.
All right, let him conclude. Then.
Yes.
Yes.
No, that is my submission, my lord. Only PW5, my lord. And my submission is that, my lord, because his conduct is so unnatural, my lord, he is not wholly reliable, my lord.
But why is your submission so timid today? You are asking for acquittal, but your submission is going down.
My lord.
Doesn't look like you mean what you say.
No, my lord.
Looks like you have been asked to do a job and you are just doing it.
No, my lord, that is not the case, man.
All right.
No. So my submission,
Okay, so we have taken note of your.
my lord.
arguments.
And
There is-
may I place just one more judgment, my lord?
Hmm?
On unnatural conduct, my lord, one more judgment. my lord. Well, this is 2020 19 SCC 165. my lord.
That is not true. This 1994 5 SCC is primarily on delay. In lodging,
Delay the anti-timing of the FIR, my lord, and in that case, my lord, the wife of the deceased, her unnatural conduct, my lord, although she claimed to be an eyewitness, my lord, because of her unnatural conduct, my lord, her testimony was disbelieved, my lord. This 2020 19 SCC 165, my lord. Para 20, my lord.
yes.
Herein also, my lord, there were two eyewitnesses, my lord,
Hmm.
brothers of the deceased, my lord. Their testimony also disbelieved because of their unnatural conduct, my lord, along with other factors, my lord. But
Hmm.
I'm only placing para 20, my lord.
There are 20.
20, my lord. yes. The assailants were only armed with hockey sticks and a knife, and not with any firearms. It seems very unnatural that two brothers present on the spot will not even make slightest attempts to intervene and try to save the other brother from being assaulted, merely on the threat extended by the assailants armed with hockey sticks and a knife. This unnatural conduct totally against natural human behavior casts a serious doubt of shadow on the presence of eyewitnesses on the spot at the time of the occurrence.
Hmm.
Well, in this case, well, there's another aspect, my lord. They did not send the brother to the hospital, my lord. The Supreme Court also observed that, my lord.
Hmm. So the court says PW1 was not corroborated by PW11.
The
PW1 is an eyewitness.
1 and 11 are the brothers, my lord. The deceased, my lord.
There was contradiction in their testimony.
Well, who hit whom and all of that, there was contradiction.
So that is the reason why court found that it was not due to the- more so due to the conduct.
Conduct, my lord. My lord, my submission in this case merely more so on the conduct, my lord. This conduct belies the incident, my lord.
So you have taken a plea of alibi. You want to say anything on that?
On the plea of alibi, my lord.
Yes.
This 2014, my lord, 11 SCC 355, my lord. Jumni and others, my lord. Para 23, my lord.
Yes.
On the standard of proof, it was held in Mohinder Singh versus State that the standard of proof required in regard to a plea of alibi must be the same as the standard applied to the prosecution evidence. And in both cases, it should be a reasonable standard. Dodnath Pandey goes a step further and seeks to bury the ghost of disbelief that shadows alibi witnesses in the following words. Defense witnesses are entitled to equal treatment with those of the prosecution, and courts ought to overcome the traditional instinctive disbelief in defense witnesses. Quite often they tell lies, but so do the prosecution witnesses. I'm placing this because of the mother, my lord. The mother said he was at Guwahati, my lord, and then she said that he was at Chandrapur because Sorla, the wife of the appellant, says that she was at Chandrapur, my lord.
But the mother also said that he was under suspension.
under suspension. My lord. His mother says that, my lord, and says that she was at Guwahati, but says that Chandrapur because Chawla had told her to say Chandrapur. But DW1, my lord, is completely unshaken, my lord. DW1 says on the day of the occurrence was a Thursday. He forgets the date, my lord. It was a Thursday, my lord. He had called the accused to come over to his hut for a putti poha, my lord.
But
He-
DW1 says it was a Thursday in Katima,
My lord, he says,
month of October, Thursday. There are at least 4 Thursdays in a month of October.
it was the month of, no, my lord, because again, then he says, my lord, he leaves in the morning, the next day, early in the morning, because the accused got the news that his house was burned down, my lord. This is in line with the deposition of the witnesses, my lord. The appellant's house was also burned down the same day of the incident, my lord. Allegedly by the deceased side, my lord. So his presence as per DW1 is, his DW1 remains unshaken, my lord. He was at his house reading the holy text, my lord. In the morning, he gets a call that his house is burned down, my lord. He leaves, my lord. And then, my lord, his arrest is also, there might be some doubt, my lord. Citation was put to the IO, my lord. How did you arrest him, my lord? He says that he got secret information, went to Ronia market to arrest him, my lord. He denies the citation that, my lord, the appellant appeared at the police station to inquire about the case lodged by his wife regarding the burning down the house, my lord, and he was arrested, my lord. In 313, my lord, he again says that when he went to the police station to inquire about his case, my lord, his house burning down, he was arrested, my lord. Lord, in this case, GW1 and PW5, my lord.
All right. Yes. Yeah.
Lordship, in the case in hand, your lordship, PW1 is the eyewitness and prime witness is the PW5 who was with the victim at the time of incident, your lordship. He is consistent, your lordship. He saw the accused person beating the deceased, your lordship. And along with the son of the accused, who is the co-accused, was also there, my lord. Lordship, and apart from that, your lordship, PW2, PW4, lordship, saw the accused person running away from the place of occurrence, your lordship. Immediately they were there, your lordship, immediately after the incident, PW2 and PW lordship 4, they, on hearing hue and cry, they came out, your lordship, and lordship, they saw the accused person running away from the place of occurrence, your lordship, and there was enough light. The prosecution could prove, your lordship, there's light, electricity connection is there in the locality, your lordship. The contention of my learned friend, the appellant side, is that there is delay in lodging the FIR and inconsistencies as regards the verses given in 161 as well as substantive evidence. And your lordship, place of arrest, your lordship. And the conduct, more
He is in
precisely the
jail.
conduct.
Appellant is in jail.
Is in jail, my lord.
Conduct of the accused person, my lord. So, your lordship, I have gone through the evidence of PW5. Here he says it's consistent with the 161 statement, your lordship. He saw the accused person beating Kubale. May I repeat the statement once more? মোৰ নাম দিগেন চৌধুৰী মই হাইস্কুলত পঢ়ি আছো আজি 26/10/2006 তাৰিখে গধূলি অনুমান 9:30 বজাত মই মোৰ দেউতাৰ লগত আমাৰ গাঁৱৰে কণ্টেশ্বৰ চৌধুৰী ঘৰৰ পৰা আহি থকা অৱস্থাত জয়ৰাম চৌধুৰীয়ে 3 ফুট মান দীঘল লাঠিৰে ফটিক চৌধুৰী ঘৰৰ সন্মুখত মোৰ দেউতাক মূৰত কুবাই কিছু দূৰত জয়ৰাম চৌধুৰীৰ ল'ৰা শ্ৰী কমল চৌধুৰীয়ে চাই আছিল তেতিয়া দেউতাক গুৰুতৰভাৱে আহত হয় পিছত জয়ৰাম চৌধুৰীয়ে মোক মাৰিবলৈ উদ্যত হয় আৰু মই উপায়বিহীন হৈ চিঞৰ বাখৰ কৰো মোৰ চিঞৰত ফটিক চৌধুৰীৰ পৰিয়ালৰ লোকে ওলাই অহাত জয়ৰাম চৌধুৰী উক্ত স্থানৰ পৰা পলাই যায় উপস্থিত লোকে জখম অৱস্থাত দেউতাক থানালৈ লৈ আহে আৰু থানাৰ যোগেদি চিকিৎসালয়ত পঠাই দিয়ে চিকিৎসালয়ত দেউতাৰ মৃত্যু হয় পিছত পুলিচক মই দেউতাক লাঠিডাল পুলিচক গতাই দিলো Lordship, he saw the accused precisely, my lord. He has mentioned the name of the accused person, my lord. He beaten him there. And your lordship, conduct of the accused regarding the conduct part, your lordship, that he did not go forward to save his father, your lordship. May I take your lordship to the two citations, my lord, as reported in 2007, 15 SCC 393, my lord. I've given the copies. Para 14. Para 14.
Para 14.
Yes. We are unable to accept the contention of the learned counsel for the appellant that the conduct of the eyewitnesses is unnatural as they had not disclosed the genesis of the incident to the members of the family of the deceased on the same day, or they had not immediately reported the matter to the police. On scrutiny of the evidence of the eyewitnesses, we have no hesitation to hold that PW 1 and 2 are natural and truthful witnesses. Their evidence is cogent, reliable, and convincing, and there is no good reason to disbelieve and discard their consistent and truthful version. It is well settled that every person who witnesses a murder reacts in his own way. Your lordship will kindly note, there is no set of rule of natural reaction. To discard the evidence of a witness on the ground that he did not react in any particular manner is to appreciate the evidence in a wholly unrealistic and unimaginative way. Therefore, the High Court has rightly reappreciated the evidence of the eyewitnesses, and we find no fault in the reasoning recorded by it. The evidence of the eyewitnesses finds corroboration from the medical evidence. Then para 19, lordship, not para 19, your lordship. Only this para of this citation, and one more citation, your lordship, 1997.
Yes.
1997 Supreme Court Criminal 261. Narayan Singh versus State of MP. Para 4, my lord. Para 3, Mr. MC Dhingra, learned counsel as amicus curiae, in this case is submitted before us that on the sole testimony of Mahendra Singh, the order of conviction has been passed by the courts below, but there is infirmity in the said deposition of Mahendra Singh. Mahendra Singh has not actually seen the stabbing. He became very sensitive when he saw the accused taking out a knife, and thereafter he turned away his face and ultimately left the place. Hence, there was no occasion to see the commission of murder. It is an admitted position that the father of the accused was also present at the place, and therefore it cannot be definitely concluded that the accused caused the said murder. If the aforesaid circumstances, benefit of doubt should have been given to the appellant, that apart the conduct of the only eyewitness, Mahendra Singh, was also strange because instead of informing the family of the deceased, he reported the matter to the brother of the accused. If this unusual behavior of the eyewitness is taken into consideration, no reliance can be placed on this witness. In the aforesaid facts, the conviction was not at all warranted. Para 4. We have considered the judgments of the courts below and the positions given in the case. It may be indicated that the High Court has rightly pointed out that normally the witness Mahendra Singh should have reported the matter to the family of the deceased, but he was a young man of 20 years at the time, and he became so perplexed by the aforesaid incident that he behaved in an unusual manner. But simply on that account, his testimony need not be discarded. We are in agreement with the reasoning given by the courts below. It appears to us that Mahendra's evidence is convincing and deserves credence. In the facts and circumstances of this case, we therefore do not think that any interference is called for. The appeal is dismissed. In our case, your lordship, the witness is about 14 years, my lord. So it's a natural behavior. He will
He was
be
14 years at the time of the
yes,
occurrence.
yes.
Nice.
And lordship, They have taken a plea of alibi, but DW1, evidence of DW1 as well as DW2 do not support that case, their case, Your Lordship. Not consistent, my lord. One of the DWs say he was in Guwahati, one was say he was in his office in Chandrapur, Your Lordship, and another says that he was due to some ritual, he came to his place, Your Lordship. It's not consistent. And the next, it's not that that on the next day he was arrested when he went to see that his house was burning. He went there to visit. It's not that, Your Lordship. He was subsequently, as per the evidence of the IO, Your Lordship, after 3 days he was arrested while somebody informed them, Your Lordship, he was loitering in the market area. So, Your Lordship, I think the chain is complete in this case, Your Lordship. The evidence of the eyewitnesses, Lordship, consistent. Even if, Your Lordship, PW1, although she has not seen the whole part, but she has seen a part, seen the accused, two of the accused persons stabbing the deceased and causing injury to the deceased, Your Lordship. As a result of it, he died immediately, my lord. So, Your Lordship, prosecution could prove the case beyond reasonable doubt. And there was previous enmity, Lordship, as a result of which, Your Lordship, the accused person might have killed the deceased. There was land dispute, my lord. It has come on record, my lord. So this is my respectful submission.
Anything in reply?
No, 1 to PW.
Oh, Lordship, one more thing, that lodging of the, sending report to the magistrate instantaneously, Your Lordship. Although 157 says so, Your Lordship, it should be forthwith sent. I've seen the police manual, Your Lordship, it doesn't say so, it should immediately send. And I have talked to some of the lawyers, Your Lordship, they said, my lord, in bulk they send to the magistrate for 1 week or so. They send all a copy of the FIRs and all. And Your Lordship, court office and fingerprint rules under the Assam Police Manual, my lord. Rule 38. First information reports and final report forms by whom to be laid before the magistrate. First information reports and final report forms must be laid as they come in before the district magistrate or magistrate in charge of police cases at headquarters and before the sub-divisional officer at subdivisions by such officer as a detail below. First information report by the second court below, but instantaneously should be placed. It doesn't say so, my lord. I didn't find it.
Yes.
My lord, PW 1, 2, 4 and 5, my lord, they've all been broken in cross, my lord. They have not seen the appellants running away. They've not seen the occurrence, my lord. It's there in the cross of the IO, my lord. And my lord, again coming to the conduct, my lord. As we say, my lord, Amar Para, my lord, our locality, my lord. This happened in his locality, my lord. Had it been a strange, isolated area, my lord, strange people armed with weapons, my lord, quite understandable, my lord. But this happens in his own locality, my lord, surrounded by the houses of his family members, my lord. That makes his conduct more unnatural, my lord. That is my submission.
Mr. Mahajan, you have already argued on unnatural conduct.
That, my lord.
There is no point pushing it in.
My lord, and PW2, my lord, his 161 was recorded, my lord, 1 year, 6 months, my lord, after the occurrence, my lord. It comes in the IO's cross, my lord. Those are my submissions, my lord.
But Mr. N. Mahajan, learned counsel for the appellant, also heard Ms. B. Bhuya, learned APP Assam appearing for the state. Arguments concluded, judgment reserved.
Obliged, my lord.
So here, we have got another matter under 8, my lord, lots of fix it today. And this item 6 and 7, my friend is there, my lord. Here, what has happened, my lord? It came into the list. We came to know about the case, my lord, yesterday only, my lord. 129 witnesses, my lord. Can it be any other convenient date? There are 129 witnesses, my lord. During the course of a day, it is
This
Item
is the
6 and 7.
Jhankar case where
6 and 7.
What is it? Business?
this is the Jhankar case where in Karbi Anglong, a young boy was killed by a mob after a fight with the auto driver for a matter of 10 rupees or so. They were not getting changes.
How many people have been convicted?
My lord, 12. my lord.
12.
They are in jail.
Jail, jail.
Although there are 129 witnesses, but the fathers and the few police officers witnesses are the most important. Others were all onlookers, bystanders. But then it will take some time. Documents, I think 27 in numbers.
My lord, honest prayer, my lord. 129 would be if she omits some, my lord, I don't know. Otherwise, my lord, it will be 129. Any convenient date, my lord, we do it, my lord.
But
Second week of December,
My lord, my lord, my lord.
Mr. B.K. Mahajan, learned counsel appearing for the appellant submits that this matter be taken up for final hearing on another date by expressing personal difficulty in arguing the matter today. The prayer is not opposed by Ms. F. Khan, learned APP Assam appearing to the state. Huh? Your legal aid counsel,
no. Father of the victim.
Mr. A. Mr. So and so is present on behalf of respondent number 2. On the request of Mr. Mahajan, let this matter be listed again on 15th of December,
My lord, my lord.
2022
Yes.
as a fixed item.
Yes.
Lordship, I'm for in item number 7. My senior, Mr. Saranya is on his legs. He had prayed that if the matter could be on 6th or 7th of December, first week.
6th or 7th, there are other matters fixed.
No, Bishop.
What is your name?
AI Qatar
Mr. A.I. Qatar is present on behalf of the appellant in item 7.
7.
Item 7. 6, 7, there are other cases fixed. 15th is okay, convenient.
For me, it is okay, my lord. My lord. My lord.
All right.
8 and 9.
Convicted on the 6th. Thank you. Thank you. My lord, 376, my lord, gang rape, my lord, and sentence is 20 years, my lord. This matter, lordship, at the stage of 389, my lord, it was heard at length, my lord, but thereafter, my lord, possibly, my lord, the same amount of trouble, my lord, dictating the judge. Either way, my lord, I'm not saying anything, my lord. Lordship heard it at length, my lord.
This matter was heard.
Lordship, at the 389 stage, my lord, there possibly lordship opine, my lord, that passing the bail order, either way, I'm not saying anything, my lord. It be like, my lord, and dictating when the judgment, my lord, would be possibly the same, my lord. And it was, my lord, with all respect, my lord.
Yes.
Yeah, my lord, may I come to the affair, my lord, with all
Where
respect,
is
my
the
lord.
paper book?
Yeah.
This cannot be live streamed.
My lord.
One appeal and the other appeal by the other convict is pending. He had appeal from jail. That is a jail appeal. The lordship have taken out the orders if your lordship wants to see that. The same. There are 2 convicts. It was your lordship's order where your lordship has admitted and called for the LCR.
And this is arising out of the same judgment.
Same judgment. 2 convicts. One driver and one was accompanying. It's an NDPS matter. দুটা appeal আছে তো এটা jail appeal আছে এটা is not listed today.
Other person will.
Oh, same card.
We are for the one accused man.
He's saying there is another appeal by the co-accused.
And their lordship has appointed Azad Ahmed as the amicus. Last order was?
Swampur Musari is the other. He is the
Yes.
other.
Yes, another appeal.
So there is an appeal preferred by him. Which is not on record. It has to be listed together.
We have no knowledge that.
Paper book is not prepared in that matter, it seems.
Same paper book will be my.
LC is not here. On that same LCR, one
It's the
LCR.
same LCA, same paper book.
Hmm.
So let it be listed along with.
Along with my lord.
Heard Mr. G. Giyasuddin, learned counsel for the appellant. Also heard Ms. S. Jahan, learned APP Assam, who submits that criminal appeal bracket J bracket close 34/2021 referred by the co-accused Swamkur SWMKUR Swamkur Moshahari MOCHAHARI is pending before this court. But the said appeal has not been tagged, has not been listed today. Full stop. Since both the appeals arise out of common judgment and order, there is no dispute at the bar that the appeals would have to be heard together. Full stop. In view of the above, the registry to list this matter along with criminal appeal bracket J public 34/2021.
But some urgency is there because our bail petition already your lordship rejected my lord, and there is
Yes,
a.
after 10 days. 10 days.
Most of them. lordship.
Anybody is there?
Part two matters. Hearing item 1, 3, 4 and 5, 7, 8, 10, 11, 12, 16, 18, and 20.
So tomorrow there is a partnered matter, is it?
Yes, we ask.
What was the case?
The evidentiary of hostile witness, my lord. The prime witness, the eyewitness was declared hostile. So how far it is admissible?
So we'll do that matter only because this bench, the combination may change next week.
No, sure.
Therefore, there is no point of making another matter partnered. We'll try to finish off this case. Who's the appellant's counsel?
Mr. K. Goswami.